Good afternoon, ladies and gentlemen. My name is Elena Mercurio, and I'm the Program Coordinator for Martha's Vineyard Mediation Program. I'd like to welcome you on behalf of the program, its members, and the people who have helped us make this event possible today. Let me first briefly speak about Martha's Vineyard Mediation Program. The program began 25 years ago in 1984, and at that time it was modeled after a program in Dorchester, Massachusetts. The late Judge Tucker and Clerk Thomas Teller, who is here today, and a group of dedicated mediators formed a program to provide free services to litigants of the Small Claims Division of the District Court in Dukes County. It was around 2002, jumping forward, when state funding for mediation programs began through the Commonwealth of Massachusetts. And because of that, Martha's Vineyard Mediation expanded its services to include facilitation and mediator training. We expanded our name at that shortly thereafter to the Center for Dispute Resolution to reflect those added services. Unfortunately, due to budget cuts, last year all funding for all community-based mediation programs throughout the state was slashed. We find ourselves now in a position of having to reach out to all of you, and for the first time we have to ask for help in order to keep our doors open. Before introducing our panel today, I would like to mention a few people who have helped us with our fundraising initiative this year. We'd like to thank Marcia Sini, an attorney here on Martha's Vineyard, who assisted us in the establishment of the Tucker Teller Foundation. Sue is here today with her husband, Bill Sini. Also, we'd like to thank attorney Skip Tomasian, who, in addition to having a private practice on the island, is the president of the Dukes County Bar Association. He has been outstandingly helpful in sponsoring this event with his generous support and contribution. Also, Susan Silk, who is now a year-round resident of Martha's Vineyard, who had a long career in Chicago in broadcasting, has been extremely helpful to tonight's program. She conducted the research and facilitated the program topic with the moderator and panelists. Let me introduce to you everyone else. To my immediate left is Ann Brown, who will be providing introductory remarks. Ann has spent her career advocating for safety in the consumer marketplace. She served as chairman of the U.S. Consumer Product Safety Commission under the Clinton administration. Ann and her husband have been longtime summer visitors of Martha's Vineyard. Next to Ann is Doug Cabral. As you know, Doug began his writing for the Martha's Vineyard Gazette in 1972. He quickly moved into the position of managing editor, and after a brief departure from the island in the 80s, he returned and purchased the paper in 1991 with his wife, Molly. Deborah Metters, who's been really the person who's brought this program together, is a director of Martha's Vineyard Mediation, and I couldn't possibly tell you the efforts that she's extended to make this event possible tonight. To my right is Judge Norman Stahl. Judge Stahl was appointed to the federal bench by George Bush in 1990. Today, Judge Stahl has returned to private practice, and he and his wife, Sue, seasonally reside in Kilmark. Next to Judge Stahl is Judge Bob Gamage. Judge Gamage was elected to the Texas Supreme Court in 1991, and he served on that court until 1995. He was also a member of the House of Representatives, the Texas Senate, and a member of the U.S. House of Representatives, as well as a justice on the Texas Court of Appeals. Today he is in private practice. And finally, I'd like to introduce to you Joe Solito. Joe has been an elected official in Dukes County since 1974. Joe has been re-elected 5 times as clerk of the courts for the County of Dukes. And with that, I'd like to thank you all for coming, and we'll let the program begin.
I will say on behalf of the panel and the guests up here that what the late, great Ted Kennedy used to say, of all the introductions I've had, that was the most recent. And so I think I'm delighted to see any of you here on this gorgeous day. You must be very serious-minded folks. And I think that at least most of us don't have to travel too far. And when I travel, I often think of the time that my husband and I were at a party that the President and Mrs. Clinton gave. And when you're on Clinton time, you wait around quite a bit. And we met both Carol Channing and the governor of Guam. I was talking to Carol Channing, the star of Hello, Dolly, and the governor of Guam walked up, and I said, "Miss Channing, this is the governor of Guam." And Carol Channing got all excited and her eyes got big, and she said, "Guam, Guam, I love Guam. Wherever I travel, my luggage goes to Guam," she said. So in case we don't have that trouble today. Now, I am supposed to warm you up a bit. And so I'm going to simply tell you a joke. Has no reason for being here except for being a joke, and I hope that this will make you feel warm and friendly toward us for the rest of the afternoon. I'm going to tell you my father's favorite story, and unfortunately, although I'm a Sox fan, it's a baseball story about the Yankees. Oh, and you know how old it is because a horse walks up to Casey Stengel, the manager of the Yankees in old times. And he says, "Hello, Casey." And Casey says, "Amazing, a talking horse." And the horse says, "Not only can I talk, I am the best batter you've ever seen, best hitter." So Casey brings him into Yankee Stadium, gets Whitey Ford in to pitch to him. The horse hits every ball out of the park. Well, Casey's very impressed. He brings the horse in. He says, "You'll back clean up for the night game." Comes the night game. First 3 batters hit safely. Up stalks the horse. First pitch to the horse, boom, out of the park. And the horse just stands there. And Casey yells, "Run, you fool!" And the horse says, "If I could run, I'd be at Hialeah." Well, I have absolutely no purpose for telling you that except it reminds me of my father, who was the only non-attorney in our family and somebody that I love very much. Now, when we think of our topic today, we have to think first of all about what is the proper role of the court in a democracy. After all power ideally in the United States is in the people. And the fundamental role of the courts is to hold elected officials to the limits of their delegated authority. And under the federal system, many things are done to maximize independence. For instance, judges are appointed for life, they get compensation for life, they can't be removed to another part of the country. Judges are supposed to be insulated from political pressure. Now, of course, when judges are elected, then we have a different situation because contributions do enter the picture. For instance, in my home state of Florida, there's a death penalty, but the judge can change the jury's verdict. For instance, in the Terry Schiavo case, as you may remember, the court decided that the husband would make the call about his wife. Well, many people in Florida wanted to change that. They wanted to have the judges change that. And so elected officials are very often subject, unwanted or not, to political pressure. Now, move all this around. Now, what is it that threatens judicial independence? First of all, sometimes judicial and the individual ambitions of the judge may threaten it. For instance, Justice Roberts in the Guantanamo case, and that established his conservative bona fides, or Justice Sotomayor and the New Jersey firefighters case. It is possible that other considerations enter. Also, judges are human beings, and they like to be admired by the people that they respect. On one hand, perhaps the New York Times, on the other hand, perhaps the Wall Street Journal. At the state level, there is a problem of judges being elected and trying to get reelected, and being subject to partisan pressures if they have collected money on behalf of their campaign from different attorneys. For example, the attorneys may be pleading a case in front of them, and there may be some feeling of political pressure. Judges have to impartially apply the law, and even the perception of partisanship is damaging. The converse of the effect of judicial opinion on the political process itself. We've been talking about, is there pressure on the judge to remain impartial? But whatever judicial opinions there are have a vast effect on local politics, national politics, the whole body politic. For instance, the immigration decision in Arizona, where the judge invalidated parts of the existing law, has had a major effect on what's going on nationally. Of course, the quintessential one is Bush v. Gore, which had an amazing political effect, one could say. And lastly, the one that comes to mind most recently is the judge's ruling on gay marriage, Prop 8, in California. The New York Times said a federal judge's decision on Wednesday overturning Proposition 8, California's ban on same-sex marriage, has tossed a largely unwanted issue into the middle of the November midterm elections. So you can see there's enormous pressure on the politic. The judge in that case is a very curiously interesting man, Judge Vaughn Walker. As you know, he was named to the federal bench by a Republican, the first President Bush. But that has not insulated Judge Walker from conservative group charges that he has ruled out of personal interest. And in this case, it has been disclosed that Judge Walker is gay. Does that have an effect on his ruling? Or should you only have men deciding about men and women deciding about the women as judges? Of course, it seems absurd, but it has been something that has been of concern. The judge did seek to have the trial televised, but he was overruled. And another interesting topic that I'm sure our panel will discuss is having TV in the court. Does it make everybody play to the cameras? Is it a good idea or not to open up the judicial process like that? This is a fascinating topic with many repercussions. And we want to hear now what some of the real-life judges here have to say. And to introduce our panelists again, we have Doug Cabral, who is editor of the Martha's Vineyard Times. Thank you very much for letting me introduce this topic to you.
I apologize for the necktie. It's been a necktie day, which is unusual for me. It's horrifying, really. My apologies to those of you who have to wear them every day. Well, this is an unusual pleasure for someone who's in the newspaper game. Judges mostly don't want to talk to us. And they certainly don't want to put themselves into a position of having to answer our questions. So I'm feeling unusually privileged. I'm going to try to restrain myself and not take advantage, though. But listening to what Ann had to say, I think she mirrors exactly the fears in the community at large, the national community, many of whom worry that judges are not impartial, that they bring to their decision-making and their judgments what they want to bring to it, and that it has nothing to do with a cultivated sense of fairness and judicial temperament. So I think it's appropriate, rather than just to brand the judges with this particular point of view, but rather to ask them, how do you process all that you hear and read, and that your wife tells you about, and that your neighbors and friends complain to you about, and that the national media and the television argument channels are noisily bombarding you with day in and day out. Judge Stahl.
I do want to correct the misapprehension so I don't get in trouble. I am still a sitting judge, although on senior status in the federal court. It's been many, many years since I practiced law, actually 21 years ago. To answer your question, first of all, I think that my experience has always been the same. Judges try to get it right. I have sat on my circuit for now 18 years as a circuit judge. I sat as a district judge for a couple of years, and I've sat on 2 other circuits as a visiting judge, where I did not know who appointed the particular judges I was sitting with, nor did I know what their political affiliations had been. And to a panel that I have sat on, I have not seen political considerations make up part of the decision-making process. We do try to get it right, and there is a misapprehension out there that somehow it's all result-driven. Certainly in the courts of appeals, where we are constrained by what the Supreme Court has said, and we try to interpret the law with an understanding of what the Supreme Court has said the law is. Now, sometimes that's hard to do. If you have a 5-4 opinion, and the 5 judges have written separately, and one of them says, I join the result, but not the reasoning, it's pretty hard to know exactly what they're telling you. And so...
Excuse me, could you just talk a little bit about the difference between an appeals court judge's role and a trial court judge's role?
Totally different. A trial judge is trying the case. He has the lawyers before him, he has the litigants before him, evidence is put before, if it's a judge trial, before the judge, if he's both trier of fact and the decider, or if it's a jury, the jury ultimately takes their instructions from the trial judge in deliberations on deciding how the case should come out. That's a totally different experience than being an appellate judge. The appellate judge hears cases on the record. The case has been decided, and usually the losing side wants to get it right, they think, and they appeal. And there are certain issues which they have preserved for appeal, and those are the issues which we decide. And we decide that on the record that's before us and on the law as we understand the law to be. Most cases are not hot-button cases. I think in the 18 years that I've been on the Court of Appeals, I might have seen one abortion case, maybe. There's a great...
People often picket outside your courtroom, or did they when you were...
There have been, there's some days when I come to work and there are pickets. I usually don't pay much attention. They may be, we had a death penalty case a couple of years ago. There were pro-death people and anti-death people out on the street. We do get that sort of thing. Occasionally with some of the terrorist cases, we've had people picketing. But I frankly ignore it when I come to work. I drive in, park my car, and go to work, and I don't think very much about it one way or the other. It does create security problems, but it doesn't create problems in our decision making. But the short answer in the federal system, and I'm sure in most state Supreme Courts, is we do try to get it right.
Judge Gamage.
I think every judge tries to get it right according to his or her lights. Judges are human beings. There are
What does that mean, his lights? Is that
Pardon?
his background? Does it mean his...
It means we all bring our baggage with us. We do come out of different cultures. We do come out of different neighborhoods, different religious backgrounds, different ethnic backgrounds, different genders, sometimes different gender preferences. We all bring our baggage, our cultural baggage with us. A judge's duty, and I think this is what Judge Stahl was addressing when he says we try to get it right. A judge's duty is the fair and impartial administration of justice. In making those decisions, in determining what is the fair and impartial administration of justice, our unique individual thought processes are at work. On appellate benches, we sit there, we have a debating society. We argue. There are majority opinions, there are dissenting opinions, sometimes there are concurring opinions that go off in other directions. My favorite case when I was on the court was 4-4, for the judgment of the trial court, 4 against the judgment of the trial court. No, 5 for the judgment of the trial court, 4 against the judgment of the trial court, 9-judge court. But only 4 for the prevailing opinion and 4 for the dissenting opinion. And that was done very calculatedly to avoid setting a precedent.
So it's perfectly understandable that Justice Roberts would think this way and Justice Souter would think that way, and they've both come to this question that they decided and acted impartially and did their duty.
According to their lights.
Right, according to their lights.
That's what the judge's duty is. We don't have 9 people on the United States Supreme Court, and in my case 9 on our state Supreme Court, because they're all going to think alike and vote alike. That's why there is a plural court. It has 9 voices on it, and you're expected to exercise your judgment independently and, where possible, to gain consensus. More often than not, it's unanimous on most appellate courts.
Is that right?
I can give you, for instance, just before I came here today, I got a 55-page fax of an opinion, which is the 3rd time I've seen it, and we are trying to reach consensus. There is a difference within our 3-judge panel about a couple of constitutional issues, and we've been arguing them back and forth for at least 6 weeks since the original first draft of the opinion was circulated.
Are you arguing back and forth over language or over principles?
In this case, it's constitutional principle. And so we will try to reach an accommodation among us where everyone is satisfied that we can have a unanimous opinion. Now, we may not reach that, and tomorrow morning, that's my job, is to decide whether I can accept this current draft in the form that it has been redrafted to meet objections of 2 of us to certain parts of what was hoped by the writing judge to be a majority opinion. You don't know whether that's going to happen yet, but that's the process. It's a give and take process. And those cases where there are contested issues of how you interpret the law, whether a right actually exists, and Judge is correct. We do all bring ourselves to the table. We are the sum of our experience. I was a practicing lawyer for many, many years. That brings a certain approach because I had clients. I handled some small criminal cases. My practice was largely in the commercial and government area, but I bring that knowledge with me. One of my colleagues on the Court of Appeals was a noted lawyer in Washington, D.C. on antitrust matters and spent time in the Justice Department in the Antitrust Division. He's an expert. He teaches at Harvard currently on the side antitrust to students. Obviously, he brings that vast knowledge of antitrust to the court when we are sitting on an antitrust case, if he happens to be on the panel. By the way, in the federal system, all cases are assigned randomly so that it's on a wheel, and 30 days before the hearing date, I get the briefs. I understand what cases I'm going to hear that month. It's a random selection.
Let me ask Joe, because Joe's been doing this for what, nearly 30 years? Yeah. So you've watched a lot of judges come and go.
I have.
Is this true?
It is true. No, it is true. All of the judges that I've worked with do take it seriously. They bring with them their experiences of life, and especially in the Superior Court and even now on the District Court, they travel on the circuit. So when they come to the Vineyard, they really don't know anything about the lawyers or the people or the witnesses that are going to come before them. Everybody is new. And it's a little different what I do compared to what Judge Stahl does or what Judge Gamache does, because I deal with people as the magistrate, both in the Superior Court and in the District Court. Very rarely, and not very rarely, but on occasions I do have lawyers presenting cases, but I handle people every day coming in for parking tickets, sitting on small claims cases, listening to speeding cases, and listening to bail in the courtroom when there's not a judge available, or doing bail up at the jail. So my experiences are a little different. And I'm the only elected person within the judiciary of the Commonwealth of Massachusetts. There are 13 clerks of courts in Massachusetts, one in every county except Suffolk, which has 3. And we're the only elected people in the judiciary that have to go out and campaign and raise money and to be elected to hold our jobs. And my position is a 6-year term.
So we're talking, because you brought up elected versus appointed, let me ask, does it really make any difference? Because to be appointed, you have to be known. You have to be admired by the appointing official. You have to be examined by the people who are going to consent to the nomination, or in some cases by a legislature. I think you, both judges, have been in state government, had been in state government before being appointed or elected to the bench.
I was never in state government per se. What I did do, in my case, was I worked with governors and had some impact in New Hampshire with one governor in particular in recommending people for judgeships.
But you do have to have an acquaintance with politics as they're practiced in your state capital, in the case of someone who's appointed to a state judgeship.
Well, let me put it this way. I had a partner who was a federal district judge, and when he was asked that question, he always said, look, every federal judge is a friend of a governor, a senator, hopefully, the president, or somebody who fills one of those positions, and he usually is a member of the party of the appointing authority. It was no different, so it is a political appointment. And anybody tells you that an appointed job is not a political appointee is not really telling you the whole story. Obviously, in my case, I had friends who were in government who thought that I would be an appropriate federal district judge, and I was asked to take the vacancy when it had occurred, and eventually I got confirmed after the lengthy proceeding that federal judges go through for appointment and confirmation. For those of you who do not know or don't know the process, we're nominated by the president. For years, the American Bar Association has had a committee on the judiciary which does an independent investigation of each nominee and has 3 categories of nominees: unqualified, qualified, and well-qualified. And those nominations, typically, if it's qualified or well-qualified, go to the Senate Judiciary Committee, which is supposed to do its own examination, and eventually you have one of those hearings you hear about before the Senate Judiciary Committee, who then votes on the nominee. It's a long process for many people, and many people never get hearings, and many people don't get confirmed for one reason or another, some good and some not so good.
Judge Gamage? Is it Gamage? Am I pronouncing it correctly?
Pardon me?
Is it Gamage?
Gamage.
But you had to run for election. Yeah, to a judgeship twice?
To the Court of Appeals twice and to the Supreme Court once.
How do you grade the difference in terms of political nature between appointed judgeships and elected ones?
All judicial selection processes are political. The judiciary is the third branch of government. I don't care if they're appointed or by what system they're appointed, whether it's outright gubernatorial or presidential appointment, whether they're elected by the legislature, whether they have a merit selection committee to sort them out and make recommendations to the appointing authority, which in most states is the governor, where they do appoint. It's still a political process.
Well, why shouldn't it be?
It should be. Whether it should be more one way than the other is the big question.
Why shouldn't college professors in law? Why shouldn't college professors in law school choose judges from among their faculty?
And if the legislature wanted to design it that way and amend the state or federal constitution, as it were, it could be done that way. They could set up any system they want to. Our founding fathers, when they drafted the United States Constitution, said, well, we want an independent judiciary. We want one who can sit out there, and while it's debated today whether judicial review was in the cards at that time or within their contemplation or not, I think John Marshall got it right. In the colonies and later in the individual states, judicial review was a common practice.
I wanted to be judged by someone who was one of us, not necessarily some cadre, but someone who.
One of us being whom? You said one of us. One of the ordinary people, one of the politicians, one of the professors.
Right. Because, for example, you don't have to be a lawyer to be on the Supreme Court, do you?
No, the Constitution does not require that. I understand that Roosevelt even toyed with the idea of appointing a non-lawyer just to get everybody's goat at one point in time. It's a political process, regardless of which system is used and devised. Political judgments do enter into it. Unfortunately, in the elective system, you got to go out and raise money. You want your judges to be non-political, but the election process throws them into the same political turmoil as legislators, state representatives, senators, governors, United States senators, congressmen. They have to go after the same people and try to get the same money to get the same voters. So they are thrown into the political process, into the same cauldron of politics. Appointive systems are a little bit different in that it does help who you know. And it does help if your talent, skills, or contributions are recognized. But it's still a political choice.
Let me turn to the question of cameras in the courtroom, because I gather that judges are mostly mixed in their view of this. Is that right?
Well, I can speak to the federal system. We don't permit cameras, and I think for good and sufficient reason. Now, that may change. The Supreme Court makeup is somewhat different. When Justice Souter was on the court, he said, "Over my dead body." And I do think that the problem with cameras is that, like everything else, the camera exaggerates what happens. And even if you have fixed cameras in the back of the courtroom, they are subject to some nightly news fellow taking a snippet, which he or she thinks is important and may have nothing to do with the case, and lead the evening news with that snippet. Jurors are often uncomfortable with the idea, and in hot-button cases they would prefer to be anonymous, even though the camera is not supposed to show them. I think there is concern. There is also concern that the lawyers and some judges may very well play to the camera rather than to the case. It's not entertainment what we're doing. I think the media views it as entertainment. All of our courtrooms are open except in very unusual cases. If you want to go to see what's happening next door, Joe would be happy to have you out there in the gallery. There are many days when our courtroom, the one that I sit in, be full. And I can remember the day that we heard the Cohen versus Brown University, which was the Title IX case which gave young women the right to have equal opportunity in sports that men had. I looked out at the courtroom when I came in. I was junior judge at the time, sitting on the left as I am here. Presiding judge was in the middle. He was from Providence, Rhode Island. I turned to him and I said, "Bruce, no smart remarks today or we'll get killed. Those are all female athletes and they look big." And I am sure for Judge Selya, going home to Providence, where he knew everybody at Brown University and where we ruled against Brown University, that was perhaps uncomfortable, because he would go to a cocktail party and perhaps run into the president of Brown, who was not happy with our decision. And, but we made it without consideration to our personal lives, and that's what happened during the civil rights movement. There were many Texas judges who, at great peril to themselves and their community, did what the law required. And so it's...
That's sort of a defensive argument. Well, for defense, in defense of the judiciary.
It is a defense of the judiciary. I think we're perhaps more important than the public sometimes realizes, and I don't think that the cameras are going to make us do our job better. I've had one experience, not with cameras, but with a streaming voice, which did not bother me. I think it has a very different effect. We were hearing a case involving a disputed gubernatorial election in Puerto Rico, which was a very hot issue in Puerto Rico, and we allowed the oral argument to be streamed directly to Puerto Rican radio. But that's different. It didn't have any real effect on what happened in the courtroom. I am afraid what it would do in the courtroom. Our court has voted, the Court of Appeals, where we could allow cameras, not to have cameras.
I can say that here on the Vineyard, there has been for some years now community cable television, and they record almost every meeting. Oh my God, they're recording this one. And they record it from beginning to end. And I've been doing this kind of work for close to 40 years now, and I'm doing it here. And the result is that the behavior of the people in those meetings, the public officials, changed. They don't behave the way their predecessors behaved years and years ago. The meetings are much longer. And at the same time, can I have a show of hands of people who turn on C-SPAN every evening to watch the House of Representatives? You watch the whole thing? There you go. Judge Gamish?
I've had it both ways. When I served in the Texas legislature, we had cameras in the chambers. They were limited. They were restricted to one position, but and there was play to the camera, obviously. There was not constant coverage, generally when some controversial subject was coming up. When I went to Congress, cameras were not allowed in the House chamber. In fact, it was when I was there that they voted to allow them in the House chamber. After seeing what I did in the state legislature, I voted against allowing them in the House chamber. Ultimately, they did allow C-SPAN in, one camera in a fixed position, or actually 3 cameras, I think. But they're only one showing at a time, and it's always a fixed position, no close-up shots, stuff like that. But one of the things I did notice in that at the end of the day, in the United States House, you have these 1-minute speeches. They have something similar over on the Senate side.
Special orders.
Special orders. And the members are not there. The member talking is the only one there, and the one waiting in line to talk after that one is there, watching. The only audience you have is 1 or 2 clerks and the people who are there getting ready to talk. They're 1-minute speeches that they can get on C-SPAN, that they can clip and use in commercials or talk to the home folks about. Basically, it's a form of show business for them. I don't know that it adds anything to their deliberations except to perhaps make them sometimes a little more dramatic or vitriolic or emotional and less substantive. By the same token, when I started serving on the court, when I was on the Court of Appeals, there were no cameras. When I was on the Supreme Court, initially there were no cameras, but we had a special case. It was sort of a landmark case, or would have been, if the court ultimately rendered a judgment on it. It had to do with our state sodomy law. And we knew it was going to be quite controversial in all of the networks, and it was getting national attention. And all of the networks wanted to put cameras in there, and ultimately we sat as a body and we agreed to allow one pool camera in for all the press. It was in a fixed position, and it didn't move around. And I don't know that anybody played to the camera because, for my part at least, and I think the others as well, we didn't even know when the camera was running. We were focused on the case. We were focused on the arguments of the attorneys. We'd all read the briefs. We were pretty well steeped in the case. And only did I know later that I was in show business when someone called me several months later and said, hey, you're on TV. And I said, what do you mean? You're on Court TV. What's Court TV? I'd never heard of it. Channel 52, you're on Court TV. Apparently they'd been running it, a couple of times a week ever since the argument. It didn't have any impact on that case because the prevailing opinion was that we didn't have jurisdiction to hear it. It was not a unanimous opinion. I wrote a dissent, but we never did sit in judgment on the case, and the United States Supreme Court later took care of it for us. I don't have a problem. Thereafter, we allowed one camera in the courtroom, one pool camera, the same policy. And I don't think it has affected that court's deliberations. The Supreme Court of the United States gets pretty good news coverage, and some people would say that they're hardy in show business. I don't know that a camera would lend anything, add to, or make their deliberations or the hearings any better. And it certainly does create the possibility of abuse and danger that they do try to make a theater out of it as opposed to a court of justice. And for that reason, I'm not ready to put cameras in the United States Supreme Court room and let the courts of appeals decide for themselves. They do, however, record the arguments in the Supreme Court now, and you can. Those are available to the press. Those are sometimes released immediately after following the arguments, and you can listen to them. I don't know why you need to see their faces. They're not that pretty anyway. Well, they're getting prettier, but historically they've not been that attractive.
Well, the other thing that I think the trial court is somewhat different. I can think of two cases, the first Menendez trial, where there were cameras and it ended up in a hung jury. The second one without cameras, the boys were convicted. There are many who think that if the O.J. Simpson case had not become a circus because of the cameras and the fact that the courtroom wasn't very well controlled, perhaps the verdict might have been different. I don't think, when I look at our own court, if we did it, I don't think it would make much difference. I think it might change how the lawyers interact with us. After all, what we're trying to get out of an oral argument on an appeal is the advice from the lawyers which helps us to better decide the issues before us. If the lawyers become more concerned with their public image and what they're projecting on TV, I'm not sure that would be a plus. I have had justices of the Supreme Court say to me, there are days when we know that the argument is really not addressed to us, it's addressed to the street. as opposed to really trying to persuade us. I think that's a risk that you take for perhaps not a great deal of gain in the long run. As I said in the beginning, I don't consider it entertainment. We're trying to come to a just decision. We do record all of our hearings. I believe it's all now available. And our recordings are better now. They're really good recordings. When I first started, they weren't, but now they are full recordings. So the material is available. And if the press is interested, they should come to the hearings. Unfortunately, we sometimes have very important cases, and I wonder where the press is. They're not there.
Oh, that particular case that we had the first one we had a camera in the courtroom on, the press was very present inside and out. There were multiple cameras outside where the demonstrations were going on.
Joe?
I have a little different opinion of it. I think that there should be cameras in the courtroom. Just like, as most of you may remember, selectmen's meetings were never televised. They are not televised, and people watch them, and they're not watching them so much for entertainment. They're watching them to find out what's going on. We do allow cameras in the courtroom in Massachusetts. There are specific rules that you have to follow. There has to be notification. The cameras have to be fixed in a position. If they're manual.
At the request of one party or the other, or is it?
It's usually at the request of the newspapers, and generally we only have 2 newspapers in here, so we usually allow both newspapers to come in. We have a special section of the courtroom where they sit, where they're allowed to take their pictures. About 3 or 4 years ago, we got a new digital recording system here at the courthouse. As Elena may know now, we very seldom have court stenographers. Everything is recorded. In this new recording system, there's the capability of recording it on a video. And they're talking about doing that within the next year or 2. And I think it is a good idea because you should know what goes on in your courtroom, not just for entertainment, but to know what we're doing. If we were having a trial tonight in the Dukes County Courthouse in the Dukes County Superior Court at this particular hour, the courtroom would remain open. Because as long as there's a judge sitting on the bench and a clerk in front of him and witnesses on the stand, or lawyers making an argument, the courthouse is open and the people have a right to come in. And I think it would be a good idea to see what we do and how we do it. Because really we're working for you.
What do you think the audience would take away from?
They'd see that justice works. And it really does work. Our jury system works. Those of you that have served on juries here on the Vineyard, it's a responsibility that you take very, very importantly. And I think those of you that have served, you see that the system really works. Every day it works. Someplace in the United States, there's a trial going on, and there's jurors listening to what's going on, and they're making decisions. And that's democracy. We celebrate Law Day every May 1st, and we celebrate that to show that we're a country, and we're a country of laws, and you are the country.
Let me just continue with you, Joe, for a second, because I'm curious as to how judges react, how they should react to confusion and dissatisfaction among their constituents over sentencing. Here on the Vineyard, we hear a lot of unhappiness because we read a lot of dispositions like this one, for example. No name, but this is a real event. There's a series of charges here. I'll just read the charges. Rape, null pros. That means the state declined to prosecute. Indecent assault and battery on a person 14 or over, null pros. Originally charged in district court, this defendant was indicted by a Dukes County grand jury in April and now faces the charges in the Superior Court. In this other connection, possession of a Class B drug continued without a finding for 1 year. Possession of a Class E drug dismissed at the request of the Commonwealth. Possession of a Class E drug continued without a finding for 1 year. Help us understand why those things happen.
In the first instance, you said the person was indicted.
Yeah,
and when it goes up to Superior Court, they have to remove the cases from the district court. They either do that by dismissing them or by null pros, which the district attorney can do. At any time, the district attorney can dismiss the charges by null pros, and the judge has no authority or any reason to inquire why it happened. You're talking about some of the drug cases. What could have happened is that the police arrested him for possession of Class E. They send it off to the state lab. The state lab comes back and said it was, shoe powder or talcum powder. And that may be one of the reasons why that did happen. Sometimes they can't prove the case. Maybe one of the witnesses is now recanting. And you really don't know that. Only the district attorney and the police department know that, and the defense counsel.
So now, as judges, could you discuss just a little bit the discretion you have in sentencing and the discretion you might like to have?
Well, let's begin with the federal system. Back in the late, I started as a judge in 1990. At that point, the sentencing guidelines had just become effective. So I sentenced people both under the old system, where I had basically within the parameters of what you could sentence a person for on a particular crime, I had discretion, complete discretion. When the sentencing guidelines came into effect, this was an attempt to make sentences uniform across the country. So if you did a crime, a federal crime in California or Massachusetts, that the sentence would fall within the same range. We delivered this very elaborate system was designed to affect how judges sentenced, and it did two things.
Was it designed by the judiciary?
No,
or Congress?
it was designed by members of Congress. The judiciary had some input into it. My then colleague, Steve Breyer, who's now, of course, a Supreme Court Justice, was then a Court of Appeals judge in Boston, and he was very important in how the sentencing guidelines developed. It became a huge issue over time, and judges became had less and less discretion for two reasons. One was the sentencing guidelines themselves, and the other was that Congress passed many more what we call mandatory minimums. So if you were found guilty or if you pled to a certain crime, the minimum sentence, say, was 5 years, so that the judge had no discretion. Eventually, the Supreme Court looked at it again, and now the guidelines are much more advisory, so the judges have more ability to tailor sentences for what they think is an appropriate sentence. I've often said to people, I could have two people who stand in front of me who have committed the same crime, and one of them perhaps deserves one kind of sentence, and the other perhaps a different sentence. We do sentence people.
Could you give some examples of what would be the factors that might make those?
Well, for instance, with the drug crimes, the weight of the drug is very important.
How much?
How much coke you're... So let's assume you're a mule. You're someone who is engaged to carry drugs. You're not a drug dealer. You've made a mistake in your life, and you're picked up, and you have 3 or whatever it is. I don't remember the exact numbers. Let's assume you have 5 kilos you're carrying. You were going to get $10,000 for that. You're going to serve a lot of time. That may be the only time in your life that you did anything like that. You may have had reasons why you did it, and so you get the same sentence as somebody who's a dealer or somebody whose business this is. I can give you one example because I've never forgotten the man's name, and I sentenced a lot of people. This was a young fellow who had a family, 3 children. He had never been in trouble in his life. They had been evicted from their home. His wife and his 3 children were ill, and he had no money. And someone offered him a couple of $1,000s to ferry some cocaine to a parking lot where somebody was going to pick it up and sell it to someone. Well, the someone that was selling it to was a policeman who was an undercover policeman. In addition to carrying the drugs there, he was a New Hampshire person. He had a rifle legally in the back of his truck. But as the guidelines and the law then read, he had minimum sentence was 2 years for ferrying the drugs, to the site, and 5 years consecutive for having the gun, because in those days, even though there was no indication that the gun was used in connection with the drug crime, it was considered used in connection with a drug crime. I had to sentence him to 7 years. After and he tried to cooperate, because under the guidelines, if you cooperated and the government thought you had cooperated, they could move that the judge reduce the sentence. The government felt he hadn't cooperated because the reason was that he didn't know anybody and he couldn't give them any useful information. The drug dealer was also brought in to me thereafter. He had cooperated big time because he was a drug dealer, and he had given them a Colombian who was the major supplier. The government came in and asked me to downward depart for the drug dealer for his cooperation. They wanted me to let him go. And I said to them, you didn't do anything for this poor schnook who made the first mistake in his life. This is a big-time Colombian drug dealer himself, and you want me to let him go? You got the wrong judge. I gave him a 2 or 3 month off for his cooperation because I thought that the guidelines weren't working very well. That's when I was a district judge. I never forgot it. The fellow eventually served his time. He came out, and I assume he did okay after he came out. At least I hope so. And I thought that was not a sensible sentence. I would have sentenced him to less, and I think today he would be sentenced to less.
The only trial judge experience I had was as a military judge, and they've had guidelines forever called the Uniform Code of Military Justice that apply to all services. The same rules apply to all branches of the military, and there are minimum and maximum sentences that can be imposed, and within that range, that minimum and that maximum, trial judges have broad discretion in the military. And sometimes it is a substantial range, so that when there are equitable circumstances or mitigating circumstances, you're not locked into giving a specific sentence. You can sometimes, instead of giving them a dishonorable discharge, if there are mitigating circumstances, give them a bad conduct discharge. It's not an honorable discharge. Sometimes the convening authority has an opportunity to review. That's the first appeal from a military trial. Convening authority can reduce it even more. Cannot increase it, however. Depending on what the equities are and what the convening authority, which is generally the local commanding officer, has had for breakfast. On the Court of Appeals, I had both civil and criminal jurisdiction. In Texas, the Supreme Court is purely civil. We have a Court of Criminal Appeals, which is virtually the Supreme Court for criminal law in Texas. That creates some confusion and perhaps even some abuse at times. But on the Court of Appeals, we reviewed sentences and we affirmed them or overruled them and reversed them.
Do you modify them or do you send them back?
We can't modify them, no. We can only send them back. They have to go back to the trial court, sometimes for a new trial, and that's generally what we would do, because if you've got a jury involved, and then juries engage in sentencing as well as judges. Actually, the accused has the option in Texas of having the judge impose the sentence or the jury impose the sentence.
Let me interrupt, because I want to be sure that the audience has a chance if they'd like to ask some questions. But I did want to say that Joe, being a clerk of court and not a judge, isn't sequestered the way judges are and coddled the way judges are. And judges very rarely see defendants flying by in their courtroom or outside. But Joe has had that experience, and he's got a great story, which I've always enjoyed hearing, and maybe you will as well.
This was during the term when Mr. Tullo was the clerk magistrate in the district court. I think you were on vacation that day. I was in my office talking on the telephone to a well-known Edgartown resident, Mr. Robert.
Second floor.
up on the second floor. My office is on the second floor, and the courtroom's on the second floor. And I was on the telephone, standing up, kind of looking out the window, talking to Mr. Robert Carroll, who some of you may know, that used to own the Harbor View, the Harborside, and the Seafood Shanty. And I kind of look over, and all of a sudden I hear this noise, and there's a gentleman coming through the screen right out this window here. And he took a flying leap out the window, and as he came down, I made an expletive and said to Mr. Carroll, "I'm sorry, I have to get off the phone. I have to call 911. And the gentleman had been arrested over the weekend, and he was coming down off of some drugs. And when the court officer uncuffed him because he was cuffed to somebody else, he just made a swing around the court officer's bench and jumped out the window, and he broke his ankle. He was very, very fortunate. We've had that happen twice. We had another fellow that went out the other window where the bathroom was. There was a young lady from the probate court eating her lunch on the back steps. He fell down, twisted his ankle. He got up and ran away. And about maybe an hour and a half later, they found him under the altar at St. Andrew's Church. There were some women that were putting the altar cloth on and getting ready for services on Sunday. This happened to be on a Friday. And that's where they found him, hiding under there. Every once in a while, we did have somebody try to get out there. We always got him back.
I do want to make sure that there isn't a misapprehension. Within the federal guidelines, judges did have a range in which they could sentence within those guidelines, and there were ways that they could adjust, but the real feeling was that it was too mandatory and too limiting, and the current regime does give the judge more room to tailor a sentence, taking the guidelines into consideration. Remember, we're supposed to be judges and use judgment. And sometimes that's forgotten.
As I recall, it was also a major impediment to plea bargaining.
Right.
And plea bargains are a very valuable tool. In the state system, probably 95% of criminal cases are disposed of through plea bargains. They're not tried. They're pleas of guilty or no contest or what have you. Same thing in the federal court, but if there's a minimum mandatory sentence, a lot of times the accused will say, "I'll take my chances. Let's try this case. I'm not pleading anything. If you've got to put me in the slammer for 7 years."
Or 30.
Or 30, maybe I can beat the rap. I'll take my chances. You can't harm me any.
It's the same statistics from Massachusetts. About 95 to 96% of all cases are settled before they come to trial.
Why is that a good thing?
We have one courtroom between the district court and the superior court, depending on the number of civil cases that you have. Between the two courts, maybe you have 1,000 cases entered every year. If each case took 2 days to try, we'd never get anything done. There's only so many hours and so many days to do it. As I tell the jurors when I talk to them in the morning, after they're getting ready to be released, in the district court they may put 2 or 3 criminal cases on. The superior court may have 2 or 3 civil cases. And most lawyers are like the rest of us when we went to school. We didn't do our homework on a 3-day weekend till probably 10 o'clock Monday night for Tuesday morning. Lawyers are no different. They don't start talking about cases until 9 o'clock on Monday morning, when they know in the district court if it's going to be a 6-man jury case or the superior court, a 12-person case. That's when they talk, and that's when they get together and they start negotiating. Either they plea bargain on the criminal side, or they try to mediate it on the civil side. But getting back to sentencing, in Massachusetts they do have sentence guidelines, and there are some mandatory sentences. The probation department has a big role to play in that, because they will do a profile on the defendant and they'll come up with the guidelines. And they will give those to the judge, and the judge has those guidelines to work. We also have in the superior court.
The prosecutor also have access to that report in the process of
they would not in the bargaining, only after they present it to the judge. And a lot of times you have unagreed pleas where the district attorney will be asking for one sentence and the defense counsel will be asking for another, and then the judge makes his decision. In the superior court, we also have a 3-judge panel which reviews sentences. They have a certain amount of time which they can appeal to this 3-judge panel, and they have the right to lower a sentence.
All sentences, or only if they're asked to by?
Only if they usually ask for them. It's not all sentences.
As another aside, I think Judge Stahl will probably agree with me on this. As a result of those rigid guidelines, when they instituted them, it started and it eliminated most of the incentives for plea bargaining. So criminal cases began to stack up for trial, and it log jammed the courts in many areas of the country, some more than others. But what it causes is for all the civil cases to start backing up because criminal cases take precedence. Took years to get a lawsuit to trial.
With your permission to invite questions.
My name is Charlie Pillsbury. I'm actually from New Haven, Connecticut, up here on vacation. And I've always been troubled by judges having to raise money to get themselves elected. And I recognize that all the judge selection process, if you explained well, is political no matter how you design it. But I'm just wondering whether you've ever been in a situation, those of you who've had to raise money, having to recuse yourself in situations where somebody who made a large donation is now before you with a matter, either in a civil matter or a criminal matter. I'm just curious whether that situation has occurred, does occur, and how often judges do recuse themselves in those, what maybe not direct conflicts, but certainly the appearance of some kind of conflict.
Appearance is the standard. Though in my experience, judges are very reluctant to recuse themselves for that sort of thing because many of them consider it an admission that somebody bought influence with them if they recuse themselves. The United States Supreme Court has addressed that issue, and they pointed out that under certain circumstances, it might be a good thing for a judge to recuse himself. When I was on the Supreme Court of Texas, the Texas Medical Association, TexPAC, their political arm, their political action committee, was trying to raise money to support a slate of candidates. They invited several current members of the court to appear and sit and be interviewed, and they used little clips of those interviews in this commercial they did. Now, the commercial wasn't broadcast to the general public, but it was broadcast to the auxiliary of the Texas Medical Association, that's the spouses group, and to other associations that were affiliated with them in an effort to raise money for their political action committee. And several of the judges who had been supported by the Texas Medical Association did that. Unfortunately, at the same time, they had this one case that was making its way through the courts, and they interviewed this doctor who had a malpractice claim filed against him. And he made comment that, we've got to elect this slate of judges. If we don't, I'm doomed. They're going to be grading my paper. They're going to be sitting on my case, and we've got to elect the right judges. And they ran that. That was part of the commercial, if you will. When the case made its way to the state Supreme Court, as it did, the plaintiff's lawyer filed a motion for recusal against every member of the court, and I think if I recall correctly, there were 4 of them, every member of the court who had appeared in that commercial. And they all objected, and first, the judge has a right to make his own judgment on whether or not he will recuse voluntarily. This was a motion to recuse, and each of those judges could have recused voluntarily. They did not. So the court was put to a system that they use when the issue is put to the court, and that is that judge left the conference room. The other judges voted on whether or not he should be recused. Of course, there were 3 of those other judges sitting in there, and they didn't want to be recused either. So at any rate, there was only one vote to recuse, or maybe 2 votes sometimes to recuse one or the other of them. I was always one that voted for them to be recused. I didn't appear in the commercial, but my name did. I had been endorsed by them, and it appeared on a slate card in there. And to me, it was not that had any influence on what I was going to do on the case. It was the appearance. What would an ordinary person out in the street think if they saw that or heard about that? And it's the appearance of conflict or potential conflict even. And in that case, I thought it was particularly aggravating. At any rate, none of those judges were recused, and so I filed a declaration of recusal and recused myself. One of the judges on the court filed a, I don't know what he called it, but it was a response to my declaration of recusal, so that they both got published. I thought it was an abuse. I thought, number one, that they should have recused. It wasn't money that was contributed to them, it was a device to raise money to contribute to them. Substantively, it's the same thing. There is an appearance, especially with that doctor's appearance, and his statements on that tape, which was a big mistake, but they did it, and it was out there. The plaintiff's lawyer found out about it, so other people found out about it. There is a tremendous potential for that appearance of conflict when you have to go out and raise money from the private sector. The reason I retired from the bench when I did was that, well, not the reason, there were several reasons, some of them were personal, but the major reason was that I did not intend to run for re-election anyway, but there were people urging me to run for re-election, so I ran up the trial balloon. I sent out some feelers, okay, if I run, will you support me? To lawyers, they're the only ones who are interested, or people with cases before the court. I didn't get a real excited response, mainly because I didn't play favorites. There was a group out there called the Civil Justice League, which included the Texas Medical Association, the Texas Association of Business, Realtors, and a whole bunch of others, who put a bunch of money into targeting judges for defeat, basically. And they would go out and recruit people to run against them and then help finance them. And I knew that they were going to come after me. I ran for, I went in 20 years, I've campaigned for 5 separate offices. I was elected to each of them at least once, but they were statewide and federal. 21 elections, 2 recounts, and 2 election contests in 20 years. 21 elections. I'm the sorriest fundraiser who ever won an election. I hated raising money. I did not like to ask for it, not because I thought anybody was going to be buying influence from me. I was more concerned about how they felt when they handed me that check. And I didn't want anybody to think they owned a piece of me.
Let me ask Judge Stahl.
Well, I calculated that in order to win re-election, Texas has 254 counties. I calculated that in order to win re-election, I would have to raise and spend a minimum of $3 million. I had not, if all those 21 offices and elections I'd gone through collectively had not raised and spent $3 million in 20 years. And I certainly wasn't going to do it in the next year and a half. And I said, it's time to drag up. I'm not going to go through that. I'm not going to put people through that.
Well, federal system is very different. We have what's called first dollar recusal. If I own a share of stock in a company, that's an automatic recusal. I have to file a very detailed statement every year, which ends up on the internet, and of our personal finances. I think it's a breach of faith that was made with us originally. Those were not supposed to be available in that form. But we do have a first dollar recusal. Obviously, I don't have to raise any money. And frankly, I never think about the person who nominated me. When in court, when I'm thinking about the work that I have to do, as I said in the beginning, in the opening remarks, I try to get it right. I think my colleagues try to get it right. And I think that the system of appointment, yes, it always depends on who gets appointed, and it varies from election cycle to election cycle, but hopefully the president, when he nominates people to the district court, to the Court of Appeals, thinks long and hard about the people that he or she will nominate, because we often have a long afterlife, long after the president who nominated us is just a distant memory. Many of us are still around.
I would like to add one thing on the money for elections campaign and elected judiciary. I think it was 1997, PBS did, Frontline did a segment called Justice for Sale. They have run that a couple of times since, and I think Bill Moyers narrated it. The message, of course, in their pitch was, in Texas politics, we have an old saying, you dance with them what brung you. Those who got you there are the ones that you're indebted to. And that may work fine in representative offices, but judges are not supposed to be representatives. They're supposed to be judges.
Other questions?
I would like one of the judges or both to explain to the folks here this evening the issues of bail, because that sometimes becomes a political challenge in that many times you look at the newspaper, regardless of which big city, and you find some newspaper reporting that the judges let somebody go and they should have held them on bail. If you would address that issue, because lawyers know about it, and it's not a matter of vengeance or seeking retribution. The issue of bail is a whole different issue that the public generally doesn't know about, and they don't want to understand.
The judges defer to Joe.
I've probably set the last, since 1973, Mr. Tello, when I was first out of law school and I got appointed a bail commissioner, thousands of bails. And the purpose for bail is not punishment. The purpose for bail is that somebody will show up in court when they're supposed to.
To secure appearance.
And to secure appearance. That's all it is. And that's all my function is. Now, as the Superior Court magistrate or as a bail magistrate, whether I do it in court, which do quite frequently, almost every day, or I do it down at the Dukes County Jail or at one of the police stations. And that's all it is. If there's a problem as to dangerousness, that's entirely up to the district attorney's office. It's up to them after they come back into court again, or if a judge is doing the bail, to say, I think this person is dangerous, and they have a dangerousness hearing. We also have now in Massachusetts what they call a bail warning, which we give now almost to every defendant, that should they be charged with a crime or commit a crime during the pendency of the action, they can be held up to 60 days without bail. And we've been using that now quite frequently. I, as a magistrate, can't impose that, but a judge can. But that's the only purpose of bail, is to ensure that the person is going to show up. Flight risk.
Can the prosecutor ask the judge to consider the dangerousness of this particular?
He can at that point in time, when the bail hearing is there. And if we have a judge here, we don't have a judge here every day. We're a rural court, and a lot of times the magistrates are the ones that have to do this. Back on days when we had only court once a week, Mr. Tulloh would be presiding 4 out of the 5 days, setting bail and releasing people. We also have in Massachusetts too, is that if somebody is arrested, they have the right to have bail set within a certain period of time. Unlike the federal system, I think, which sometimes they can be held over the weekend, we have to respond. If I get a call that somebody's in jail at 12 o'clock at night, within 6 hours, I'm supposed to respond, or sooner than that, to give them a bail hearing at the jail and set the bail. If somebody is arrested and they cannot come up with the bail, we have what they call the Jenkinson hearing, and that happens on weekends. If they don't get bailed within 24 hours, either myself as the Superior Court magistrate or Mrs. Williamson as the District Court magistrate, we're required to go to the jail and hold a hearing to show that the arrest, there was probable cause for the arrest. If we found out that there wasn't probable cause for the arrest, we automatically release them from the jail. And that's one of the
At the time, in the middle of the night when you're called, the police have arrested someone, do you have possession of information about his background, that there are outstanding warrants, that he's on probation, in anticipation of a court date?
We do have that now. Back when I first started doing it, we'd get out of the jail, we'd make a call to Boston, and there'd be somebody on duty in the probation office that used to go through file cards to tell you whether somebody or not had a record. Under the system now, by the time the police call me to come, by the time they process them, with the computers they know whether or not, if he has an ICE detainer, which would mean that somebody is here illegally, they can hold him on that. They'll know if he committed any other crimes, if it's been the same type of crime that he's been arrested for, if there are outstanding warrants from another jurisdiction. I know all of that.
If he's on probation.
If he's on probation, I know all of that, what his record is by the time I get to the jail. And if I want to go look it up myself, I can just come down to the courthouse and, go on our own computer.
In the federal system, it's a long time since I had to do this, but we do have we have rules, and it is to ensure that people show up, and there is a question, if there's a question about whether they're dangerous and so forth, the U.S. attorney will certainly make it known to the judge or the magistrate.
Would have to demonstrate to the judge. Yep.
Whether we're talking about an appellate court versus the court where it stands trials and sorts, the names I'm told differ from state to state. It occurs to me that when Socrates was convicted of his 2 crimes and put to death, it was done by about 402 judges. So that would be a body of thinking people who would be hard to influence or even have the appearance of having been influenced.
It would be roughly equivalent to the number of people in the House of Representatives.
Well, they don't think. I didn't think of that. But I mean, the people in front of me, I know 2 out of the 3 of them, and I regard them as thinkers. And what I've heard, it's 3 out of 3. We've won that game. But it seems to me that it would be very, very difficult for unusual influences to enter the scene of a very large court. I don't know how to implement it. I'm just thinking in terms of just the principle of working in that way. I mean, Roosevelt tried to pack the Supreme Court. I don't think he...
That was only because he didn't like what they were doing.
That's right.
Not because he thought
that was wrong.
There were too few of them. He just didn't like the few of them that were there.
But ask yourself, are judges subject to being influenced? That same court started operating a little differently after his court packing plan, even though it failed. What was the old saying? A switch in time saves 9?
It wasn't as crazy a decision as a lot of people think. I teach this stuff, but actually there are a few interesting recent books on the trial of Socrates. He wasn't so innocent, to say the least.
I'm not sure what you're suggesting, that we, before we impose the death penalty, or in every sentencing case, that we have multiple justices judges at the trial level.
Well, I mean, he drank the hemlock. There's nothing left for him otherwise.
He was an honorable man.
Actually, in Massachusetts, up until about 1875, 3 judges always sat on capital cases. In fact, they had Judge Gamache at our courthouse. Our courthouse was built in 1858, and if you look at it, there are 3 distinct sections on the bench up on for the judges, and 3 judges sat on capital cases up until I think it was about 1875. So they had more than one. Yeah.
It's a beginning.
Was anyone ever acquitted back then, Joe? Or were they all hung?
Probably all hung back. It was a little different back then.
Particularly if they were witches.
Yeah.
Anyone else?
My name is Courtney Brady. I'm from Edgartown, and I just wondered whether professionally but also personally, whether you had any experience with mediation, and what is your hopeful, positive take on it?
I'm sorry, I didn't get the first part of the question, did you?
Yes,
Whether you have had an experience professionally
mediation.
or personal
And
with
what we
mediation,
think about it.
and whether you have, we hope, a positive attitude.
I'll start off with that. I think we do have some mediators here, and I do some small claims cases. And before I even start them, when the group of both plaintiffs and defendants are out there, and they're usually representing themselves, they're not lawyers, I always ask them first to go to mediation. I really strongly suggest that they go to mediation. And because they're going to make the decision, and they will decide what they want, and usually they might be happier if they make the decision. If I make the decision, I'm probably going to make both sides unhappy. But as I tell them, that's what I'm there for, is to make the decision. But it would be preferable if they try to make it. And I will give a plug for the mediation group here. They do an excellent job. In the years since they've been doing mediation, primarily they started doing it with the small claims cases. They've really taken a great burden off the court system. And those people that have gone to mediation really appreciate the results that they've acquired through that.
Mediation worked right saves a lot of time, a lot of money, and a lot of anguish, and allows the people to make the decision for themselves. One thing you have in mediation that you don't have in a trial, whether it's a judge trial, a bench trial, or a jury trial, and that is certainty of outcome. I do a lot of mediating. That's what I do now. I do a lot of ADR, arbitration and mediation. Arbitration's a lot easier. I can sit up there and make decisions for other people all day long. Mediation's very difficult because in many circumstances, and most of the cases that I do mediate, lawsuits have been filed, a lot of discovery has been done, people are pretty well locked into their positions. There's a lot of emotion, there's a lot of hostility, a lot of tension, a lot of stress, and what Joe said is absolutely true. The first thing I tell them is that this is the last chance you have to make the decision yourself. You have opportunity for absolute certainty here. You can fashion a remedy for this dispute that the court is not going to care about. You can work it out so that both of you win, or at least you don't lose as much as you may lose if you go to court. When you go to court, any lawyer will tell you, and any judge will tell you, there's no certainty of outcome. It depends on how the jury hears the case, or how the judge hears the case, where the jury's sympathies are, or where the judge's sympathies are, or whether the judge applies the law properly or wrongly to the facts as found by the jury. There are a lot of, and it's a lot of time, a lot of stress, and a lot of expense. Mediation is the way to go if you can get there. It's very difficult. I do some pretty complex mediations involving multiple parties from time to time, and I do a lot of follow-up. Some of them aren't resolved until weeks, and in one case even months after the formal mediation. And mediation, by that I don't mean it's a formal process. Mediation is a very informal process, totally flexible. There are no rules. In Texas, any mediation agreement is subject to enforcement by the court. It will be enforced by the court as basically it's a contract, and the court will enforce it. The great thing is also there that anything happens in a mediation, if it fails, is totally confidential. Neither party can divulge what occurred in mediation, what was said in mediation. The judge cannot ask what occurred in mediation, and the mediator cannot be subpoenaed to testify or produce any documents. So it's a very informal process, and it works very well. It does take time. It does take a lot of sensitivity, crawling into the other person's shoes and into their skull and trying to see where they're coming from and bring people together who don't want to be brought together in most cases. Sometimes it works real quickly and easily, and other times it's very difficult. But it is a magnificent process, and it's a tremendous alternative to litigation.
Yeah, I couldn't agree more. When I first became a district judge, I got a letter from the administrative office of the federal courts advising me that I had the oldest docket in the United States, and what was I going to do about it? I wrote them back and I said, I've only been here 2 weeks, give me a little time. And what I did basically was I set up my own docket. I knew which lawyers were likely to try cases and which ones never did. They were first on the list for trial, and in 2 years, I had winnowed it down to about 2 years. Mediation is an excellent idea. We call it in the federal system, we have settlement judges who do this work. We have our own in the Court of Appeals. We have a retired state court judge who acts as a settlement judge. We never know about it, but all the civil cases go through him, and many of them get settled before they come to us. It's good practice.
What a nice question. Segue to the end of our program. Thank you, Courtney. And that is, and I want to actually begin to say a big thank you. And we do want to thank Ann Brown, Doug Cabral, Judge Norman Stahl, Judge Robert Bob Gamage, and Joseph Joe Solito, and also Susan Silk for the time, research, and sharing your all's knowledge and your skill with us this evening, and that to the program. And on behalf of the Martha's Vineyard Mediation Program, we hope that you have learned more and have broadened your knowledge about our judicial system in our country. That was our intent of our program this evening. The program has been taped, and it will be viewed soon, or can be viewed soon, on MVTV. And we will also be making it available to our social studies and civics classes here on the island to use in the classroom. And for those who might have joined us after we commenced, I want to thank again and recognize again Thomas Teller, who was one of our co-founders 25 years ago with the Honorable Herbert Tucker, and also Marcia Sini, who has just been tireless at times with her advocacy on behalf of the program. We would like to extend a thank you to Andrew Carr with MVTV, Chris Scott and Janet Heath and the staff of the Martha's Vineyard Preservation Trust and the use of this lovely facility, and also to the law offices of Tomasian and Tomasian. And now we'd like, if you would take a few more minutes and stay with us and join us for a few refreshments downstairs. And you'll have an opportunity to interact with our panelists if you would like. But again, join us downstairs for a light refreshment. With that, thank you very much on behalf of the Martha's Vineyard Center Dispute Resolution.